Hi there. This is Dr. J. Kent Gregory, and welcome to part two of Chapter Four's Alternative Dispute Resolution. So we are going to pick up with just before, well, where we left off with mediation. So this is a method of ADR in which, like all of them, parties work to form a mutually acceptable agreement. So in this, they actually do not, in parties in mediation, do not vest authority to decide the dispute in a neutral third party. So the authority remains with the parties themselves. So they're going to do it themselves. And they're free to terminate the mediation if they believe it's not working. And it's really only appropriate, as you can see, for those willing to participate in the process. It's confidential, and so that has its benefits for people who wish to avoid the public nature of litigation. And the process is usually faster and it's substantially less expensive than litigation. And keep in mind, litigation can be very, very expensive. And then there's a mediator. This is the person who facilitates a mediation to achieve an acceptable voluntary agreement between the parties. So the mediator doesn't have any authority in him or herself. They just help the two parties or three parties, as the case may be, arrive at a mutually acceptable conclusion. So prior to the mediation process, the mediator asks the parties to sign a mediation agreement. Uh, then the mediator explains the process. These are going to be kind of the rules of the road that everybody in the mediation or the two parties will agree to. Sometimes there are opening statements, face-to-face communication, indirect communication through the mediator. Uh, Mediator suggests options for resolutions and alternatives. Uh, so that the mediator is just there to guide the parties through the process. So the need for mediation. It's an option for parties who can't negotiate with each other, but who could reach a mutually acceptable resolution with the assistance of a neutral party. So this often happens with divorce proceedings. It often happens with in B2B cases, so business to business cases where the two parties uh, have either such a mutual dislike or distrust of one another, but yet at the same time they agree that an agreement could reach. So here we have it. It's used in disputes between employers and employees, businesses and consumers. Benefits and drawbacks. The benefits, it seeks a win-win outcome. It's confidential and it's faster. Drawbacks. Uh, if participants aren't willing to participate, if disputants aren't willing to participate, it's not going to work. It can even fail even after effort by the parties to come to an agreement, and parties cannot always be satisfied with a mediator. Um, so key takeaways, uh, mediation, the parties retain the power to decide the issue. Uh, the mediator helps them to receive an acceptable voluntary agreement. Although it's non-binding, mediation resolutions are not binding on the parties. These resolution agreements may be incorporated into a legally binding contract. So that can be the agreement can be memorialized into a legally binding contract. No uniform set of rules for mediators to become licensed, and the rules may vary state by state regarding requirements for mediator certification. So in many states, you can receive certification as a mediator. So arbitration. This is another method of ADR, and in it, they vest authority in a third party. So this is a third party neutral maker who's going to hear the case and issue a decision. So the two parties aren't going to come to an agreement together. They're going to accept the agreement of this third party. So the arbitration award, this is the arbitrator's decision that he or she has rendered after hearing the cases presented. And then it becomes confirmed and converted into a judgment by a court. So it becomes formalized in a legally binding contract. So arbitrators, they preside over the proceedings. They're neutral decision makers. Their decisions do not form binding precedent, as would a case before the courts. They are members of the judiciary, but in arbitrations, they are not judges, although they do act in an analogous capacity to judges in trials. And they're certified by the state in which they arbitrate, and they may arbitrate only certain types of claims. So mandatory arbitration. This results when disputes arise out of a legally binding contract involving commerce, and in which the parties agree to submit to mandatory arbitration. And state law requires parties to enter into mandatory arbitration. And mandatory arbitration is often dictated by the contract between the parties that are in disagreement. And then there's the mandatory arbitration clause. So the Commerce Clause. So this is a clause in Article 1, Section 8 of the U.S. Constitution, and it gives Congress the power to regulate interstate commerce. So this particular clause is very broadly construed, and one of its more broadly construed aspects is that it covers mandatory arbitration. So this is a contractual clause, so it's in the contract that requires the parties to submit to mandatory arbitration in the case of a dispute arising under the contract. So mandatory arbitration clauses frequently foreclose any possibility of appealing arbitration awards in court. So it's final, right? That's designed to be final. In it, there's a prayer for damages. This is the litigant's request for remedy or judgment, and voluntary arbitration also exists in business disputes. So that brings us to the end of part 2, and we'll continue with part 3.